Okay, so shall we start? Welcome, dear Dr. Turki Al-Shubeki, Dean of the College of Law and International Relations, dear Dr. Muhammad Ayhan, Dean of the College of Engineering, dear colleagues, friends, and students from the College of Law and College of Engineering, welcome to this first public lecture on law and public policy. Thank you for joining us. We often encounter in law and in other subjects this term public policy, for example in civil law and procedure and international dispute settlement. We also know from legal practice that there are growing need for specialists in this area. Some law firms here in Riyadh setting up departments for public policy and regulatory affairs. Interestingly, we also learned that some of our law students, some of them are present here, they learned about public policy early in their degree because they did a summer internship with the United Nations Development Program. So we are very fortunate today to have with us our guest speaker, Professor David Hoffman, who is a professor of law and public policy. Professor Hoffman is a Steed Family Professor of the practice of cybersecurity policy at the Stanford School of Public Policy, and holds a senior lecturer fellow appointment at the Duke University School of Law. He also formerly was the Associate General Counsel, Director of Security Policy and Global Privacy Officer for Intel Corporation, where he spent 23 years as a part of the legal department. Professor Hoffman also chaired the Civil Liberties and Privacy Panel for the Director Advisory Board for the U.S. National Security Agency and is currently a member. He also chairs the board of the Center for Cybersecurity Policy and Law. Professor Hoffman also founded and chairs the board for the Triangle Privacy Research Hub. He serves on the advisory board of the Paradigm Capital Group. He also has founded Resolute Data Protection LLC. Professor Hoffman also previously served in the Department of Homeland Security Data Privacy and Integrity Advisory Committee and the Board of Directors of the National Cybersecurity Alliance. He has also served in the U.S. Federal Trade Commission's Online Access and Security Committee, the Trade for Strategic and International Studies Cybersecurity Commissions, the Steering Committee for BBB Online and Trustee Board of Directors, and the Board of the International Associations of the Privacy Professionals. He is the author of many papers and articles on cybersecurity and privacy and has testified to the U.S. Congress on these topics. Professor Hoffman's research and teaching has been aided and funded from Intel Corporation and many other organizations. So the topic of today's lecture is Security and Privacy Challenges in the Digital Age, the Apple versus FBI Encryption Case. The professor will speak for about 30 to 40 minutes. Then we will have the Q&A sessions, and please be reminded that we are recorded. Welcome, Professor. The floor is yours.
Great. Thank you very much, Dr. Abdul Malik. And thank you all for coming. Everyone doing all right today? Oh, excellent. That's great. I'd like to have this to be a little bit interactive. I'd love to find out, you now know a lot about me. Thank you very much for the introduction. I'd like to learn a little bit about all of you. How many students do we have in the room who are studying law? How many students do we have here who are studying technology in some form or another? Okay, and do we have students here studying business at all? Several. That's excellent. The whole entire theme of this lecture is the intersection of those three areas, and that we're going to talk about that a bit. It's also been the entire theme of my career. So we're going to talk about how it played out in a particular and specific situation. Next question for all of you. How many of the students have been to Washington, D.C.? Show of hands. Oh, several. That's great. Does anyone know what this building is? And do any of the students know what this building is? This is the Jefferson Memorial. It is the memorial just off of our National Mall, and serves as a recognition of one of the primary authors of the U.S. Constitution. Within that memorial, there is a plaque. And the plaque has a quote on it, which also has been one of the guides for my entire approach to my career and the advice that I have provided to clients and the way that I have asked the teams that I have managed to do public policy. And it is this quote. It's Thomas Jefferson saying, "I am not an advocate for frequent changes in laws and constitutions, but laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths discovered, and manners and opinions change, with the change of circumstances, institutions must advance also to keep pace with the times. We might as well require a man to wear still the coat which fitted him when a boy, as civilized society to remain ever under the regime of their barbarous ancestors." This, as we often talk in the United States about looking to our founding documents for the core principles that we are going to apply to the law, stands for the proposition that we also need to recognize when do advances in technology, when does innovation give cause for us to look for modifications to those approaches. That dynamic of the intersection of law and concepts that were created long ago and serves as the foundations, rooted as an expression of values for society, and then how to apply that in new and interesting situations, I think is the great challenge for many of our civilizations. So as I have looked at that, I look at when we talk about progress, however we want to define progress, I look at it as the intersection of three concepts: technology, law, and policy. We'll talk particularly that when I refer to policy, I mean public policy. And we'll talk a little bit about that I don't mean a written down policy somewhere that is really a rule for people to follow. I mean the exercise of the discipline of public policy. So let's dig into this. I'm going to take this presentation in three parts, and we're going to go through each one of these and look at their intersection within a specific example. Let's start with technology. The particular technology that I want to talk about are implementations of cryptography across our computing technology and our communications technologies. What we have seen, for good reasons, to try to provide the foundations of security, we have provided the capability for individuals and organizations to encrypt a significant amount of their content. This, though, gives rise, while we are promoting the security of the information that is encrypted and the security of the systems on which that it is encrypted, it creates challenges when we have need to access that information. So just a show of hands here, how many people carry a smartphone with them during the day? All right, almost everybody here in the room. And our smartphones now integrate cryptography into the different applications that we use on those phones and into the storage on those phones and the storage that exists if you are using cloud storage as a supplement to the storage on your phone. So as we have then propagated that globally across the technology, it gives rise to questions that we need to ask of what are the implications of that implementation of the technology across all of the different uses that we have for it in society. And so here's an example of Telegram. Telegram specifically set up as a company in the way that it's deployed to actually make it more challenging for governments to be able to request information for from Telegram. This is something that we're seeing globally, and it creates a unique challenge. Show of hands, does anybody here in the room, including the faculty members, know who either one of these two men are? All right, shout out their names. Tim Cook. Who's the other person? No idea. Okay. And I wondered if anyone would know. This man, his name is Bruce Sewell. Bruce actually used to be my boss at Intel Corporation. He became the general counsel at Intel and then left to go become Steve Jobs' general counsel at Apple, and then after Tim Cook took over at Apple to be the general counsel there. As we talk about this particular issue of cryptography being deployed on phones and what the implications were, this landed on Bruce's desk, so to speak, because it was the innovations in the iPhone that gave rise to concerns that the US government had about how it was going to execute some of its core basic governmental functions. And so you can see here the arc of at least part of the technology developments that happened over time with the iPhone it still amazes me actually that it's only been 17 years since we've had the iPhone. If we think about the pace of adoption of the iPhone across society and its increased use for lots of the things that we used to do in other ways in our personal and professional lives, in just 17 years, it's one of the fastest introductions and adoptions of technology in human history. So we look specifically at what happened with the way security was done on the iPhone, you can see a development from 2007 to 2015 of data on the phone becoming much more secure over time. And I want to particularly highlight the 2015 move with iOS 9. This is what gave rise to the specific dispute between Apple and the US government. Because I highlighted the most significant change here, which was the move from a 4-digit passcode to a 6-digit passcode. From a cryptography standpoint, being able to brute force attack a 6-digit passcode instead of a 4-digit passcode, significantly more difficult. When you couple that with the other security mechanisms that Apple put in place, I don't know if anybody here's had this example, something happens and you can't remember your passcode, and all of a sudden it starts saying you have to wait a certain period of time before you can guess again your passcode, getting to the point where then after a certain number of wrong guesses, it will permanently lock the phone with the memory being encrypted. Those two mechanisms, the 6-digit passcode and those mechanisms for the timeout of guessing the passcode, made this so that it was so significantly more difficult to get access to the memory on the phone that the US government had great concerns that it wasn't going to be able to accomplish, particularly law enforcement investigations. So this is the technology piece of what we're talking about, that all of a sudden a dramatic change that has happened in society. You can see a couple of quotes in this. People didn't know how to react. Some of the most informed people on how to adjust to changes in technology. You can see the Supreme Court Chief Justice John Roberts. This is a quote that he put into his opinion in Riley versus California, where he makes quite clear in that opinion, this is not just any other new technology. Cell phones and the way that they are being used can completely transform our life. If you go on to read that opinion, he will talk quite eloquently about what does it mean when you carry something with you all of the time, when you take it into the areas that in most cultures are most sensitive and most private, including the rooms in which you sleep in your house, including to areas where you are having private conversations with the members of your family. But at the same time, that he is noting that, President Barack Obama is saying, well, wait a minute, let's not overemphasize the phone. You can see he's saying we need an answer here. He said, I suspect that the answer is going to come down to how do we create a system where the encryption is as strong as possible, the key is as secure as possible, it's accessible by the smallest number of people possible for a subset of issues that we agree are important. How we design that is not something that I have the expertise to do. Some people referred to this as President Obama's unicorn statement, saying like, I'd love it if a unicorn existed. I don't know if a unicorn exists, but boy, I wish somebody would go find one for me. And that was the challenge that was given in large to the technology industry to say, how do we solve this issue? So as people looked at how they were going to do it, this is where the law came in. Now, I have done this, this topic as 4 different 2-hour-long classes altogether to track all of the law that's actually implicated here and how it came to be addressed. We're not going to do that. We have a short period of time. So we're going to do this very quickly. So for the law students here, we can have much deeper conversations about this. But I want to highlight just a couple of the legal aspects. First, I want to isolate that when we talk in the United States about applying legal concepts here, we always go to our root foundational document, which is the Constitution of the United States. When we are talking about law enforcement being able to get access to information, we're then talking generally about the Fourth Amendment to the US Constitution, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And this shall not be violated, and no warrants shall issue, but upon probable cause. So just to decrypt, pun intended, this particular message or language in the Fourth Amendment, what this has come to stand for is that there will not be a search of someone's home, a search of their personal effects or their body, or a seizure of some of their property without going to a court and law enforcement demonstrating to that judge, this neutral arbiter, that there is good enough evidence, probable cause, to suspect that a crime has been committed. Now, there's over 100 years of jurisprudence on defining each one of those terms. We're not going to do that, but just to understand, we're not talking necessarily about completely prohibiting being able to get access to information. What we're talking about is within that system, it's really about what do you have to show to a judge to get authorization for law enforcement to go take that specific action. So, and that was what we would call getting a warrant from the judge to be able to go do the search or the seizure. Okay, so we have to add something on top of that. What we are talking about in the dispute between Apple and the US government is actually, it's important to note, they had a warrant. There was no question that they had probable cause and were determined by the judge to have probable cause to be issued the warrant. They followed the proper process, and what they said to Apple is, look, we don't necessarily just need the phone, we need the information that's on the phone. But as I showed in the developments of the phone, Apple's response is, we don't have the information that's on the phone, and the keys to decrypt it are only available from the individual who owned the phone originally. You need to be able to know the password. So the response then was saying by Apple, we can't give you what you want. Yes, you have a lawful warrant, to be able to do this, but we're not going to be able to give you the information. What the government then did is said, we have determined actually that while you can't give us the information, you could design new software to put on the phone, and on a specific phone, which would deactivate that feature of the timeout provision for the passcode, and would allow us to then do a brute force attack on it to guess all the possible 6-digit passcodes and then to be able to access the information. And Apple's response generally early on was to say, we're not required to do that. You have a warrant saying we have to give you the information. We're not required to actually develop software that actually then subverts our security procedures that we put on the phone. So what the government said is, oh, actually, there is a second legal provision that dates back still from the founders of the country that does allow us to do this, and it's called the All Writs Act, a provision from 1789 that actually states that once there is a legal warrant, that the government can use this act to get cooperation from people to effectuate what is required in the initial warrant. So it's you can see the language, All Writs Act is very short. The Supreme Court and all courts established by acts of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. This came to stand for, once you have a warrant, you can ask for assistance to be able to go effectuate this. Oftentimes this might be if you knew something was in a safe and there was a third-party organization that actually knew how to unlock the safe. You could use the All Writs Act to say, we're compelling you to go unlock that safe to get what's in the safe out for us. So over time, there's actually a 3-factor test that is used to see whether you can use this. It's from the 1977 case, United States versus New York Telephone. And this is, once again, we could do more of this in the Q&A if we want. They're going to ask the question of the closeness of the relationship between the person or entity whom the proposed writ is directed and the matter. So in this case, I think most people would say it's close enough. Apple made the phone. So they are a party who was implicated here. They're close enough that this could. The reasonableness of the burden, so the government can't impose something that is so unreasonable in their request that it will cause great harm to the organization or individual they're requesting it, and the necessity of the action that is being asked. It was the reasonableness of the burden and the necessity, as highlighted, that Apple greatly contested. These are the basics of the law that came into play in the situation where Apple then refused to comply, and the US government brought a cause of action to compel them to comply. This gave rise, as this was going through the courts, to what I would refer to as the public policy component of the issue. So the end case was never finally determined by the court, and we'll talk about why that was the case. When I say public policy, once again, this is how I define public policy. I am not talking about a government organization issuing a statement or a policy. I'm talking about how decisions are made to address societal problems. The study of that, the processes that are put in place to actually remedy the problem. So here, organizations were presented with this issue of the conflict between the government and with Apple, with the idea that this would create precedents that would implicate lots of different organizations, including the one that I worked for, Intel Corporation, which, remember back when I showed the picture of Tim Cook and Bruce Sewell, Bruce had been the general counsel of Intel before and actually had helped me to stand up and to organize Intel's internal organization on privacy and data protection. So this cartoon, I think, captures the way people were thinking about that societal problem. This idea, you know, folks are lining up for the newest Apple product. Let's hope they never invent it. And this idea that people kept saying, look, if Apple develops software that's going to circumvent the security procedures of the phone, people thought, well, lots of other people are going to be able to use that same functionality. Now, that's a much deeper conversation that we could have about whether that is technically accurate or not. Let me just give a very short version of that, because that could take more time than we have, to just say, let's remember, let me give you a little bit more of the facts of this specific information. We're talking about one phone that the FBI had physical possession of, was willing to give that physical possession of that phone to Apple, for Apple to install some software onto that phone so that they could then get access to that information. I think it is common knowledge, not confidential at all. The technology industry had provided that kind of assistance to the US government, and other companies around the world do for many years. It's very common where a government would come and say, I need some help, I have this device, I need some, I have a lawful purpose for doing this, a court has agreed with me, I need some assistance to do this. In general, people have always provided that assistance. What Apple felt was too far was once we develop this, to be able to do this for this one phone, what does this stop governments from asking us to use this on all phones? And this, I think, was the core of when I talked about the New York telephone case and the reasonableness argument, the questions around how much is this going to impact Apple? How much does it impact from a business perspective what their competitive advantage and differentiators were about how they were empowering their users? And would it actually decrease security over time to have to create this software? So as the dispute started playing out in the courts, this is where both sides started to reach out to other organizations to ask for assistance and to express opinions of how they felt about the case. So this came to me at Intel Corporation along with our general counsel and our senior executives, because Apple was a very important customer of Intel Corporation. We provided microprocessors to them. We also were in similar situations. There are cryptography implementations in microprocessors and in chipsets. There are technologies that can be used to assist with circumventing security procedures in those microprocessors and chipsets, all the way down to using electron microscopes to read the bits of the keys that are stored in the chipsets and in microprocessors. So Apple came to us and said, look, we would like your assistance here to express your opinion in pushing back against the government's request. At around the same time, the US government approached us and said, look, we have a very good working relationship with you. You operate some large semiconductor manufacturing facilities across the United States. And when there are threats to those facilities, we've always collaborated very well to be able to address those threats. We're hoping that you would be able to express an opinion here that we followed lawful process. We had a judge say that we have a need to get this information. We're only talking about loading the software in a controlled environment when we have physical access. This is similar to what the technology industry has done for decades. How will you help us with this? This was the problem that got presented to me as trying to figure out what the course of action is. This is a core public policy issue when you are working within a large corporation, that you draw upon your technology expertise, you draw upon your business expertise, you draw upon your legal expertise to try to come up with the best recommendation you can moving forward. It is in an entity like Intel Corporation's interest to need a well-ordered society where security is provided and that they can collaborate with government. It's important, though, for a company like Intel to have the trust and confidence of the individuals that are using the devices and to be able to innovate and provide the highest level of cybersecurity that we can. So we ended up taking two actions. Number one, we decided this is now the company policy, not public policy. We needed a position. We needed a position that we would ratify, that all of our executive team would feel comfortable with, that we could share with the board of directors, and that we could release publicly. And we decided, look, Apple is a very important customer, and we think we are a significant player. We should file an amicus curiae brief, a friend of the court brief, as an advice to the judge hearing the case of what we thought the right solution would be. This was a very difficult challenge. Once again, we had interests in both areas. What were we possibly going to do? So I will tell you what the end result here, which is all public information, is. After quite a discussion, we isolated what was difficult was we were trying to figure out what exactly is the problem. I would assert that when you're doing public policy, the first step that you need to take is you really need an assessment to crisply define the problem. Let me explain a little bit why that was difficult in this situation, which was really common. What data are we talking about? All right, well, the data in this particular situation was at rest and actually was on the phone itself. But it very well might not be. And depending if we're going to set a precedent, we wanted to differentiate, like, are we talking about data that's in storage? Whether it could be a storage on the endpoint device, it could be on an enterprise server, could be stored in the cloud. Are we talking about data that's being transmitted over the telecommunications network and over the internet? And whether that's going to be encrypted and there needs to be something to intercept that? Or are we talking about data that's actually in use, that the individual is using at that particular time in some way and needs to be able to be accessed? All of those potentially would drive different public policy responses. We also want to say, look, depending upon what the government need is, we might be in a different problem and have different solutions for that. What are we really trying to do? This was deemed to be a national security case, but it wasn't clear that the solutions were going to be limited to just national security situations. We asked the question, like, well, what if there is a child exploitation issue and the technology is available to be able to access it? Is it tenable to then say we're not going to use the technology to access it? Similarly, you can do it for any legitimate government purpose, whether it's combating drug crimes. If it's drug crimes, we're talking about tens of thousands of phones across a country the size of the United States that would potentially have information that would need to be able to access. Or let's talk about non-strictly criminal law enforcement provisions generally, but things like tax evasion, collecting taxes, a very legitimate government purpose. Would we want this technology or this solution to be used for that? And then also, even within that, what are we actually trying to do with this? Are we trying to actually identify an individual who is a bad actor out of the overall population of citizens? We'd usually call that finding a needle in a haystack. Do we know who we're looking at, but we actually want to, over time, understand what they're doing? Do we actually want to find who else that person might be working with? Or are we talking not about just finding this information and stopping a crime? Are we actually talking about going through the process of collecting evidence that would be used to prosecute that individual in court, which also might require different solutions? So to wrap up, And to get us to Q&A, we ended up defining the problem very narrowly, but we thought it was fundamentally important that the individuals who used computing devices based on Intel's microprocessors and chipsets knew that we did not believe that backdoors should be inserted for government entities and that they could feel confident in their use of the technology. We're not going to go through all of this, but I wanted everybody to see, like when we're talking about a position statement, it gets complicated very quickly. We went through, and this is the former policy statement. What I want to isolate within here is really this last piece. That what we tried to do is we tried to show, yes, we believe that there are legitimate government purposes and we are going to collaborate, but there are steps that go too far. So we said, like other companies, we respond to lawful demands for information from government agencies, but we will not build backdoors into our products and we will not comply with government requests to weaken the security in the design of our products. The challenge then was, as we were writing the amicus curiae, how do we then take our public policy position statement and represent that in line with the law? And so we did a lot of research, and this is what we ended up doing. We started very isolated. What are our core messages? What do we really want to convey in this amicus curiae brief? And it was two. Technology companies should assist law enforcement according to the law. That Congress has considered this issue and not required the type of assistance that the government was requiring at this point in time. This was the innovation that, working with outside counsel, we came up with to really say what we found was there is an existing law from 1994, the Communications Assistance with Law Enforcement Act. This is aimed at telecommunications providers and requiring them to place hardware on the system so that when there is a warrant that's been obtained with lawful purpose, they will be able to provide information about the information that's in transit. So this is basically how in modern telecommunications networks do you do an authorized wiretap? What we found going through congressional testimony is on the floor of the US Congress, there had been a discussion by members of Congress of, should we extend this beyond telecommunications providers? Should we extend this to the people who make computers, to require them to include this? And they decided not to include that language in the law. So we made the argument, this has been considered by Congress and not imposed. For the executive branch or the judicial branch to impose something that Congress appears to have considered and not included or imposed would be a violation of separation of powers and going too far. And instead, what this should be done is kicked to Congress, and Congress should address whether it believes that this kind of assistance is necessary, instead of using, as we showed before, this fairly vague language from 1789 in the All Writs Act. Now, there are arguments on the opposite side of this. We recognized that just because a couple of members of Congress get up on the floor and have a discussion, that's different from Congress actually explicitly stating in the Communications Assistance with Law Enforcement Act that they prohibit the government from actually requiring. And so how to handle these situations where it's not clear that it's not clear that it's authorized, it's not clear that it's prohibited, and it falls in this middle ground area, ends up being the challenge. I mentioned to you that the court never ended up making a final determination. That's because the government actually ended up creating a relationship with an entity that figured out how to crack the phone without doing this. So that's also fascinating, because you remember back to the New York telephone case, the necessity was one of the elements of requiring assistance, and gives rise to the question of, well, if you eventually could have done this anyway, why were you requiring this at this point in time? And should the government already have, should the policy solution be, or the public policy solution be, that the government should already have this type of capability, so that it shouldn't be requiring the private sector to assist in something that's a core government function. With that, I think we can go to Q&A.
Thank you. Thank you for a very fascinating lecture. I like the way that you applied historical legal concepts and principles to current legal issues, questions about public policy, how to analyze the problem, and the point mentioned in this brief, lawful demands, how do we respond to lawful demands as governments. So I've used my chair position, and I will start the first question before giving it up to the floor. Was human rights one of the components of the case? Because it seems to me that Apple is in favor of the rights of privacy, and whereas the governments, I think this is true around the world, is that in favor of other rights to life, to security, to prevent harm, and also due process, etc., etc. So in those basically discussions with the court, etc., was human rights laws and regulations? Because I often think now, in international law scholarship, that when companies operate overseas, they don't care much about human rights. You usually think about it in terms of local laws and regulations. So was it actually a component of this case, and how did both parties respond to it? Thank you.
Yeah, so a quick response. Can everyone hear me? In the back, can you hear me? No? All right. In quick response, the answer is yes. A slightly longer response is, I would actually say my experience is that many technology companies are integrating human rights into their product development significantly. And Apple, if we think back to the New York Telephone three-part test, the reasonableness of the burden was one. I think one of Apple's strongest arguments was they had already stated that their phones that they were creating actually were integrating human rights, and privacy was a fundamental competitive advantage for the phone. And so to actually compel people to do something to make it less private and therefore less secure actually was something that was an unreasonable burden for Apple.
Have any good questions? So you need to switch off the...
Oh, yeah. Let me do that. That'll be easier.
Yes, we can see.
Okay. Thank you very much for your presentation. Very interesting. I'm Dr. Federico from the College of Law. Just a couple of questions, consideration. I remember that a few years ago, Apple discussed, I don't know if they implemented, a system to automatically search on iCloud's picture to see if there were pedopornographic pictures and so on. Of course, this was done, putting in place a lot of, anonymization procedure. The picture was transformed in pixels, so we're not really able to see all the picture, but just to see there were hints of this. I don't know if they implemented this. There was a lot of discussion, and was this a reaction from this case? Because you mentioned child crimes as one of the possible crimes that would be trigger some type of cooperation, if you are aware of this. And second, in Intel, when you were discussing what to do with this policy, did you also consider the counteraction that a refusal of cooperation could trigger? Because the data are encrypted on all devices, but then in order to be able to read them, there is a moment on the device when the data is not encrypted. And all those data can be accessed every time that they steal our bank account and this kind of stuff. It's bad because there are software. Pegasus, for example, they are able to access all the data on the mobile. So refuse to cooperate on this can push agents to develop even stronger tools, because in the end, they did, and I don't know the algorithm, I do believe it was SHA-256, the one that is standardly used for encryption. And if they've been able to hack it, it means that the state of the art of encryption nowadays, at least, is not safe. So if we can do that, that can trigger a thing. There have been cases in which tools from the national security agencies have been stolen, have been published on the dark web. So was all of this also part in the policy making discussion that we had?
The responsibility of the corporation to the public, basically.
Yeah, let me take the second first, and then we'll go back to the question about Apple's separate campaign there. The answer is yes, and I have a slide that when I do a longer version of this that is actually a hand squeezing a balloon with the idea, and this is why it's so important to articulate what is the problem statement that you're solving. If you are really just saying we are going to protect data at rest, you then are going to say to governments, look to try to intercept the data in transmission, or when it is used using some sort of scraping technology or something that's actually seeing the or recording the data when the individual's actually being able to call it up on the screen or use it in some other way. I think that's absolutely right. That was a core part of the discussion, and also recognizing that there were legitimate needs for government to be able to do all of that for people to live in a productive and secure environment. There was a conversation that I thought was actually done in a very good way in the United States, and which was a recognition that if we want to be able to exercise the civil liberties that allow us to enjoy our lives, we have to have a base level of security in society to feel comfortable going out into public and being in association with each other, that we're not going to be at risk. So to a certain degree, this was positioned as security versus privacy. I think many of us thought it was much more complicated than that. And it was about what's the best way to provide security which actually provides our ability to be able to exercise our human rights without it negatively impacting individuals and organizations. So that's my response to what was a fantastic question, and shows deep knowledge of this issue, so thank you. On the first issue, I don't work for Apple and never did work for Apple, so I have to be careful that I don't want to imply exactly what they were trying to accomplish. I will say that there was a very complicated situation where they were trying to investigate different mechanisms where they could understand whether there were exploitative photographs that were being stored on the iCloud to once again react to legitimate requests from law enforcement to be able to do this. The issue gets to be incredibly complicated from a technical perspective on exactly how you are doing that, how often is it scanning that, what's the knowledge of the individual about that, to the degree that it drives false positives that could have a significant negative impact on individuals for a period of time. My understanding was that when there was a large amount of attention that was given rise to the issue, Apple backed off and did not end up implementing the proposal.
All right. So thank you for the talk, first of all. I don't study any of the things discussed, so excuse me if my...
What do you study?
I study medicine.
Medicine, excellent.
But it seems to me that there's a bit of a, let's say, pattern where in these types of cases, it feels like the corporations and the governments discuss the ownership of data or access to data, but that the individual is rarely ever represented. It's corporate interest versus government interest. And you could argue that both of these serve individuals in different ways. But my question is, how is the individual represented in these types of privacy cases?
Consumer.
Yeah, a fantastic question about how is the individual represented in these cases when the main actors are companies that make technology and the government. And let me first say I am so delighted that there is at least one medical student here, and maybe some other medical students. Think about the degree that these issues impact medical information and patients. And so trying to create an environment where patients are going to be willing to come to doctors and share incredibly sensitive information that could be used to disadvantage them, and how is that information going to be protected? I actually teach a class called Cybersecurity and Health Data Policy specifically, and we have a lot of folks training to be doctors who take the class. And what I would say is I think you have hit on a core issue. There were a number of civil society groups that did get involved, and it also submitted amicus curiae briefs like Intel did, and that was one method to do that. I would say in their defense, I think Apple did a very good job of representing the interests of the users of the technology. And I do think that we charge these organizations with not just representing their own profit motives, but also representing the interests of individuals. I think Apple really did it, and that doesn't always get executed very well. I thought Apple did a fantastic job of that. I will also say that the FBI, I think if James Baker, the general counsel from the FBI, was here, I think he would also represent to you that the FBI believes that they represent individuals. And it's actually what they're trying to do, and they're trying to protect people from harm. And so it's not, maybe not always as simple to say, how are the individuals represented, but it may be what individuals and what interests of individuals and how, and it gets much more complicated.
Any questions? Yes.
Hello, thank you for that. I'm Dr. Julian Watts-Lynch. I'm Assistant Professor of Entrepreneurship at College of Business. It's my first week, and I'm really delighted to see such a comprehensive discussion. I thought you covered and laid out the issues extremely well. I was curious about your actual view, though. I don't know if you stated it. And I was trying to think of a good analogy for what an iPhone represents. Because one analogy we could use is like a locked box in your house, like a safe in your house. And traditionally, I don't think any society has recognized the rights of an individual to harbor a box that no authority could ever access in your home, regardless of what it does. But another analogy might be like a human mind. And certainly in the West, we've recognized that people have the right to have private thoughts that are inaccessible by perhaps government. So I don't know if either of these analogies sort of serve, but it seems an iPhone is sort of somewhere in between. But I'm also curious about your actual view.
Yes, so really, very quickly, I will say, first I would really encourage all of you to read a book by my colleague Nita Farahani, which is a book in defense of the privacy of the brain and her concept of cognitive liberty, and your last point of how important thinking about that it is, that the idea of increasingly we will have technology that is going to actually be able to determine what we are thinking. And so the precedents that we set with these other technologies, we need to understand where they're going. Let me then take the lockbox example as a way to explain to you at least some of the thoughts that I have on it. What if the assertion by many of the cryptographers that I know and who wrote papers on this, one of those exercises I participated in was, imagine a situation where someone is saying that we want somebody to create a key that will open any lockbox, and that we want you to then store that key that can open any lockbox in a place where other people may know where you're storing that. And what risks come from that, of whether people are going to go get that master key that could be used for anything. I think this was the concern that a lot of people have, and I have to some degree, about whether asking people to create something that could be used to access technology, whether other people are going to be able to get a hold of that, and it's actually going to significantly decrease security. But we actually do that. We call it the software update functionality on technology. We actually have the capability to load new software onto devices. What we do is we have very secure processes to try to protect the software that's coming into the update. But for anybody who was impacted by the recent CrowdStrike issue, you can see like what happens when there's something in software that's being pushed by an update. So my view is I think there are solutions here, and that they require a level of detail around what does it mean to collaborate. Are we talking about really creating master keys, or are we talking about just when you've got physical access to one device and you would actually just be able to impact that device that's, instead of pushing something remotely to all devices. And this is, I thought, this entire issue, my last closing opinion on this was, like many other important law and public policy issues, once it got into the public debate, the nuance went out of the conversation. And it's like the government wants to access all your information, which was never true. And, or it was Apple doesn't want to assist law enforcement in any of its legitimate purposes, which was not true. The importance was in the nuance and the depth of the conversation.
One last question here.
Hello, Professor. First of all, your talk was very interesting. You said that Apple was very concerned about protecting their users' privacy, but ever since this case, it's come out that several tech companies like Google and Facebook have been selling their users' data to others. So how did Apple react to that?
Short answer, because we have a lecture after this.
Absolutely. I think the answer is that Apple believes that its respect for individuals and privacy is a competitive differentiator versus Meta, particularly Meta and Google, which do not have the same history of showing that respect.
Thank you. Thank you very much for this lecture. Thank you for coming and joining us. Thank you.
Thank you all.